The sale of property from a conservatorship estate. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine Scale Form PC 647. Scale for State Court Administrative Office, PC for Probate Court. This form is readily obtainable. You can contact my office. We'd be happy to give it to you free of charge. It's the order following a request of the court in a conservatorship file for authorization to address issues relating to real estate. So it has a specific context, which is use within a conservatorship estate when a conservator is trying to dispose of, sell, mortgage, pledge, place a lien on real estate. With all of the scale forms, they are created or they are guided by various statutes or court rules. And here with the floating yellow arrow, I've identified the two statute, MCL 700.5422 and 5423. Now again, to really understand how these statutes function, you really have to read them carefully and work with a skilled, competent probate lawyer to make sure that you're navigating through this process correctly. Because probate and conservatorship issues are not intuitive, not easy to do. So we don't suggest you ever try to do this without working with a lawyer. Let's work our way through this particular order. Now again, an order is an entry following a petition that has been filed with the court. So before this order would get entered, there would have been a petition regarding real estate. So you'd be asking the court through motion and petition process for a particular request to occur. You'd file that petition with the court. There'd be noticing requirements for service. The matter would be scheduled for hearing. The court would make an adjudication, and then the court, as we say, speaks through its orders by issuing the entry of this court order. The top left corner would identify the county in which the conservatorship is, and the top right corner the case number. The next part is pretty intuitive. It's the name of the estate, and often people think the word estate only means when somebody has died, but we call conservatorships estates also. So here it is a conservatorship estate, the date of the hearing, and the judge. This part also pretty intuitive. It says a petition was filed on, and the date of the petition, for the approval to sell, dispose of, mortgage, pledge, lien, or place a lien on the protected individual's property. So a conservator has all sorts of rights that are defined under Michigan statute, and the statutes that we referenced earlier make up part of those rights. But what they don't have is an inherent right to sell, dispose, mortgage, pledge, or place a lien on property without a specific order of the court. So if a person under conservatorship wants to sell real estate, they have to get an order. If somebody wants to place a lien on real estate in which somebody is subject to a conservatorship, they must also get a court order. So here you're asking the court for the authority to do this: sell, dispose of, mortgage, pledge, or place a lien on a protected individual's dwelling, real property, or interest in real property. So it relates to land. This next section relates to what the findings of the court are in that petition. First, of course, that notice has been provided under statute and court rule to all of the interested persons that are affected. Under the definition, there are particular rules relating to who is an interested person under Michigan law. Section 4A, there's a checkbox. It is in the protected individual's best interests. And then again, is this a sale? Is it disposing of? Is it a mortgage, a pledge, or a lien on the property? So you check that box in the event that the court has found that they find it in the best interest to authorize this transaction. The B part says the evidence does not provide the fair market value. So again, there's a requirement to be assured that if you're selling, for example, that you're not just selling it without a determination of the fair market value. So for example, often we see family trying to convey real estate from one family member to another while somebody's under conservatorship. It has to be conveyed at arm's length, should be done with a fair market valuation, and that the property is being sold for that amount. Of course, the court may authorize the transaction nonetheless, but this shows that everyone is acting with arm's length. The next is that there's a bond, and a bond is simply a guarantee of the performance of the conservator. And a bond is either a personal bond or surety bond, and that guarantees the performance of the conservator. And often in the sale of realty, the court is going to issue a bond equal to the amount of the net proceeds that are coming in. And that's to be assured that the conservator appropriately takes the sale proceeds, for example, and places them in the appropriately identified fiduciary account, and then manages those assets correctly, so that in the event that the conservator breaches their duty in some way, the asset is protected in the form of a bond. Section 6 identifies the legal description or the VIN number if it's a manufactured home or vehicle for the titled property. The next section really repeats itself. Now, this is the entry of the order. This is the part where the court is stating what has been ordered by the court. Again, the petition date, the authorization of the conservator to take particular action. You want to be really careful about language here, because the language within that order is going to go potentially to a title company, a mortgage company. It's going to be part of the closing, and if you're not accurate with the language, it could hold up the closing. So if you fill this section out incorrectly, and then you show up at closing and the legal description's wrong, or the terms that the court has entered are not accurate or correct, it could delay what you're trying to accomplish. So again, there's a section that says under the terms and conditions stated in the petition or under the following terms. So again, if the court changes the terms as set forth in the petition, the second checkbox is used. And then there's some space for the court to add some additional language. Section 8 says that the order shall be recorded with the Register of Deeds for the county in which the property sits. Now remember, a Register of Deeds is simply a repository of recorded documents, deeds, mortgages, and so on. And a court order can also be a recorded document. So again, this checkbox allows for the recording. The next, under 9, indicates that if the court is requiring an appraisal, that the appraisal will be provided within a certain amount of time. And 10, if the court simply denied the original petition, there's a spot for that to occur. The court can add additional restrictions, requirements to this order, of course, and there's a spot for the judge to sign with a date, and then if there's an attorney involved, for the attorney's information to be provided there. Again, this is used in a particular context. It's really important that you do this carefully and correctly, because you can get yourself into a whole heap of trouble if you don't do it correct. So we urge you to work with a skilled, competent probate lawyer. At the Probate Pro, we're passionate about everything probate. If you have a question about a conservatorship, probate issue, trust issue, or you just want to talk, give us a call at 833-PROBATE or visit us at theprobatepro.com.